So, like how Patrick is, how his development company is set up. So he's basically acting as a fiduciary. Does the word fiduciary exist in Spanish language?
Absolutely, fiduciaria.
Fiduciary. Okay.
Fiduciaria. And I'll be honest with you, there are projects that come under the fiduciary arrangement. Mm-hmm. Absolutely. And it's usually with banks. So sometimes you'll see a project, and the project is backed by Banco de Reservas, Banco Popular. That's the fiduciary. Yeah. Those they're the providers. So it's just my only problem with, and I like it because it guarantees that the money to complete the project will always be there.
Exactly.
The problem is that in their due diligence, when they're trying to kind of sift through applicants, they tend to get a little creative. I had a situation where they had a client pay a reserve, and then they made a few payments. They put them on a payment structure before I got a promissory note. So I called them up and I don't pay money without an arrangement, sweetie. That's not going to happen. Even a reserve. If you pay a reserve and you change your mind, what are the conditions behind that reserve? And let's say it's $5,000, but you change your mind, circumstances change, you no longer want that property. Do you get it back? Of course. How much are you getting back? I had this one guy, there was no reservation agreement. They wanted to keep half. I'm like, well, in the magical land of Narnia, you might. Now you're only getting 20. So you owe my client money. So no money is paid without it being tied to a written condition. Terms and condition, people. Even if it's a reserve, it's still money. So you can't do. So fiduciaries, my only issue with them is that when it comes to legal paperwork, they're kind of lazy. And they give you all this, they want to, they're so concerned about doing their due diligence on the person themselves that they forget legally you're still bound to provide a written agreement because there's money involved. But it's usually a good idea for projects to be tied to fiduciaries.
It's difficult too because I always apply my Canadian 22 years of selling real estate, owning a mortgage company, owning a development company. But I was selling at that point. Here, I do not sell. I'm the managing broker, so the sales process is by the team. So I can remain separate in a sense from the transaction, which if you traded in the U.S. as well. Did you have a, yeah. Mm-hmm. So it is very, very complicated in Canada for that reason. And so if I look at it in the organization that we have now, we can be the mortgage provider or mortgage brokerage, private lender, one or the other, the buyer and seller representation, the developer. So you have to have these separate angles, and if you don't keep separate pillars that you're disconnected from, you may own the company, but somebody else makes the licensing decision on it. So that's how we've set it up internally. Like our mortgage company's based in Canada with a licensed mortgage broker that's my business partner. I run the financial side, but he runs all the approvals, so I never see any information about anybody's application because I don't want any responsibility to do with that. So I use the same sort of philosophy with legal, that the contract comes in, I have the draw requests, like I explained earlier, so therefore everyone is clear because I don't want egg on my face. I don't want, if the buyer, if you will, fails to show up, because that's another thing that can happen. You can get halfway through a build and a divorce kicks in, or a death or an illness or life change or just a disappearance. We've had that in the past. And then what do? So there has to be clauses for both. If the developer fails to deliver or the buyer fails to show up for whatever reason.
And I can't stress that enough. It's the contract. Contract is important. I don't think I've ever seen one contract that I haven't, redone some clauses. I don't think there's been one in my entire career where I could say you can sign it as is. And one of the things I want to say, present company excluded, in the Capitol, the developers are slick, okay? They're always going to, provide contracts that protect the interest of the one party. Yeah, isn't that something?
I know that how it is.
So you're like, you're missing a few clauses here.
Why is it all one side?
So you find that we have to redo the clauses, add in some clauses, strike this out. That's when it gets a little sticky.
And never be afraid to bring that up as a buyer. You're the one who's investing. You're spending your hard-earned money. I've always said to myself as a buyer, if I don't understand, because I don't understand Spanish, written or otherwise, so I have to rely on representation. So I ask 7,000 questions for where, if I spoke the language, I could understand it. So you have to sort of, this is the item, and talk around the item from all the different angles of protection, who, what, where, when, and why, on everything, so to make sure that you understand how you can be screwed or will be, etc.
And also something to keep in mind is that because the legal language here in the Dominican Republic is Spanish, all legal documents have to be signed in the Spanish language. So what we offer for our clients is we always recommend that they get their own attorneys, like always, always, always. There are some builders that will say, no, we have the contract, we already have that, you don't have to pay anything. Many of the builders will come with a contract. And as far as what we do at Keller Williams, we always recommend that our buyers get their own lawyer. Don't just sign what the builder gives you, even if you can speak Spanish, because those contracts are put together by lawyers for the builders, and it's everything leaning towards the builder. So we always recommend, like, for example, like what you said, because our lawyers always come in and they want to change something or fix something or create some penalties if the builder is late. So, and also, in general, we have the contracts that are split in two. So one side is English and one side is Spanish. You don't always see that, but in general, that's how we have the contracts, where you can actually read in English to understand what you're assigning, although what, your signature will have to be also on the Spanish side of the contract. So, if you're going to spend $100,000, $150,000, $200,000, spend that little bit of extra money to protect your investment by getting a lawyer, like Maria here, to represent you, to review and everything. Don't just sign a contract from a builder just because they have it, and don't try to save a couple of dollars and put hundreds of thousands of dollars at risk.
100% agreed.
And I love it when you have a developer send a contract to a buyer in Spanish and they're pressuring them to sign. I'm like, and what exactly is it that you're signing? Do you understand any of it? So you see, Cheryl is responsible because she said something key. She sends it in both languages. You understand? Even if you have an attorney, you still have to know what you're signing. You still have to know, what you're agreeing to. So having it in both languages is just responsible. Okay? And so if you have someone put a legal document in your face where you're spending thousands of dollars, but they don't even give you the courtesy. So I'm paying you $150,000, $200,000, you can't even translate this for a couple of bucks. You might want to rethink that, folks.
And Google Translate is not the best method
No.
to use to review your legal contracts.
No, it isn't. No, it isn't.
And not only that, but get representation, because your lawyer is there to protect you. What the builders will give you is there to protect them. Period.